Welcome to another X Space hosted by Democrats for an Informed Approach to Gender. I'm Lisa Simione. Democrats for an Informed Approach to Gender, or DIAG, is a 501c3 organization dedicated to shedding light on the harms of gender ideology. We are fighting the erosion of women's rights and the medical scandal of so-called gender-affirming care. If you'd like to learn more about DIAG and join us, go to our website, di-ag.org. And while you're there, check out our merchandise store. Today's topic, whether female sports can be reserved for women and girls. On Tuesday, January 13th, the Supreme Court will hear oral arguments in two cases involving male plaintiffs who wanted to compete against females in states that have banned this practice. The cases are Little versus Hecox, which originated in Idaho, and West Virginia versus B.P.J. To fill us in on what's at stake and how these cases are likely to play out, we've assembled a crack team. Elspeth Cypher is a former justice on the Supreme Judicial Court in Massachusetts. She currently serves on the board of WOLF, the Women's Liberation Front. Kara Dansky is a civil rights lawyer, a self-proclaimed radical feminist, and former president of the American chapter of Women's Declaration International. She also served as senior counsel on criminal justice law and policy at the ACLU from 2012 to 2014. Glenna Goldis is a lawyer in New York with experience in government, fraud investigations, and domestic violence advocacy. And in addition to our legal eagles, we have an athlete, Mariah Burton Nelson. She played basketball at Stanford University and then after that professionally. She now writes Stronger Women on Substack and is a member of the Women's Sports Policy Working Group. Welcome to all of you. And before we get started, just one quick request. I'm going to be calling on each one of you in turn, but if you'd like to jump into the conversation, at any point, just go ahead and do it. But please identify yourself when you do so we know who's talking, because we have four guests here and we don't want to get confused. So thank you. Let's start with Kara Dansky. Kara, if you can, please give us just a brief summary of these two cases. What's at stake? And let's start with Little versus Hecox in Idaho. What's going on? What are these cases about?
Sure. Thank you so much for having me. So the Idaho Fairness in Women's Sports Act was enacted and signed into law by Governor Bradley Little in March 2020, and it was the first state law to protect women's sports. So that's the reason that the Idaho case is called Little versus Hecox. Little is the name of the governor of Idaho who signed the law. The law makes a series of legislative findings, including a quote by the late Justice Ruth Bader Ginsburg, where she said, in an opinion in the case of United States, Virginia from 1996, that there are inherent differences between men and women, and that these differences remain cause for celebration, but not for denigration of members of either sex or for artificial constraints on an individual's opportunity. The Idaho law requires all educational institutions in the state to designate sports teams as being open to males, females, or as being mixed, and states that athletic teams or sports designated for females shall not be open to students of the male sex. The law also says that disputes regarding an athlete's sex are to be resolved by the educational institution by requesting a health examination provided by the student's healthcare provider, verifying biological sex. And I know we'll be getting into how people can verify biological sex later with Mariah. The ACLU, my former employer, filed a lawsuit a few weeks later in April of 2020. The plaintiff in that case was a 19-year-old male college student named Lindsay Hecox, who wanted to compete in women's track and field and cross country. They alleged that the Idaho law violated both Title IX and the Equal Protection Clause of the 14th Amendment. Now, for reasons that are not entirely clear to me, the Title IX argument has disappeared from the Hecox case. I don't entirely understand why, but the only argument now before the Supreme Court in the Hecox case is the Equal Protection Clause of the 14th Amendment. The West Virginia Save Women's Sports Act was enacted and signed into law in March of 2021. It's almost identical to the Idaho law. 2 months after West Virginia enacted and signed into law its law, the ACLU sued. The plaintiff in this case was, at the time, an 11-year-old boy named B.P.J., whose puberty had been blocked and who wanted to compete in girls' track and field. They presented essentially the same arguments. From what I can tell, the only two differences between the cases are that in one, the male athlete is an adult, and in the other, the male athlete is a minor whose puberty has been blocked. The second way in which the cases are different is that both involve the Equal Protection Clause of the 14th Amendment, but only the West Virginia case also involves Title IX at this point before the Supreme Court. There are 3 lawyers who will argue in each case, one representing the challenger, Hecox and B.P.J., one representing the state, Idaho and West Virginia, and one representing the current presidential administration. We don't know yet the individuals who will be arguing these cases, but it is my understanding, based on behind the scenes conversations, that for Idaho and West Virginia, the state solicitor generals will be arguing for the states.
Okay, so these two cases are similar but not the same. Thank you, Kara Dansky. Let's go to Glenna Goldis next. Glenna, Kara actually mentioned something about this administration, and so that makes me wonder why this is even happening, because the Trump administration gave these executive orders, or gave an executive order saying basically girls have to compete with girls and boys have to compete with boys, and the twain shall not meet. So that restored the original intent of Title IX, presumably. So if Title IX protects the rights of women and girls, and it still exists as law, then why are these cases even happening?
Well, there's a lot of confusion over what that executive order did, in part thanks to the media. So I can say that the executive order did not change the law, did not even offer a new interpretation of the law. And that's not what executive order should do. So what it did was it quoted a recent court decision that said sex means sex, not gender identity, in Title IX. So, if people are trying to sort out the history, you remember the law, the statute always said sex, not gender identity. Joe Biden, his education department put out some regulations that said that in parts of Title IX, sex means gender identity, essentially. Not the parts having to do with sports, but it might have impacted it, and it definitely muddied the waters. So he put out those regulations. They were challenged in court, and as being, outside the scope of what could possibly be done. They were challenged because only Congress gets to write laws, not executive agencies. So just before Trump came into office last January, a court ruled on one of those lawsuits and blocked Biden's rule and said, no, sex means sex in Title IX. So then when Trump issued his executive order just a few weeks later about women's sports, it doesn't offer a new interpretation. It quotes that court decision saying sex means sex. And mostly what the order does is it tells the Education Department and the Department of Justice to prioritize enforcing that law to protect women and girls. So that's what the executive order does. And it doesn't really play a role directly in the legal arguments because, again, it's not the president's job to unilaterally decide in an executive order what the law is. They're citing court decisions and things like that. But it does set the priorities. And it may be the reason why we are seeing the Department of Justice up here in this case, with the Solicitor General arguing it, because they don't argue every case that goes before the Supreme Court, but they prioritize this one perhaps because of that executive order.
So this makes me curious. Does that mean that we could be hearing arguments about Title IX at the Supreme Court in these two cases?
Yeah.
All right, Kara, let's go to Glenna Goldis. Thank you. Let's go to Kara again, Kara Dansky. What exactly, I mean, can you tell us what the ACLU is going to be arguing in both of these cases? I understand that one's going to be heard first, other one's coming right after it. What's the essence of the ACLU's arguments?
Right. So my understanding is that the Little versus Hecox case will be heard first, and the West Virginia versus B.P.J. case will be heard second. And in order to understand the ACLU's arguments, you have to understand a little bit about the Equal Protection Clause. So it was only in 1971, in a case called Reed versus Reed, where the Supreme Court decided that women count as people under the Equal Protection Clause. The Equal Protection Clause is part of the 14th Amendment, which was ratified in 1868. And its main purpose was to remedy centuries of discrimination against formerly enslaved people and their descendants. And in 1971, a young lawyer named Ruth Bader Ginsburg argued before the Supreme Court that women actually count as people and that we deserve equal protection of the laws. And the Supreme Court agreed, and they said that sex is a protected characteristic. The law on that evolved for many decades. And at some point, the Supreme Court decided that laws that discriminate based on sex are subjected to something that in the law is referred to as intermediate scrutiny. I understand that's legalese. We can't totally avoid the legalese here. But the gist of what that means is that there are classes such as race, religion, national origin, and alienage that are subjected to something called strict scrutiny. That means that if someone files a lawsuit complaining about discrimination on one of those categories, there's a very high bar that the judges will apply. There's another level of scrutiny called rational basis, which applies to most other categories, and that's a very low bar. Sex exists sort of in the middle. And basically, what it means is that if a person complains that she or he has been discriminated against on the basis of sex, that complaint will be evaluated on the basis of intermediate scrutiny. And it basically means that courts have to decide if the law furthers a compelling government interest, and if it's closely enough tailored to that government interest to justify it. The gist of intermediate scrutiny is to say that laws that discriminate against people on the basis of their sex are bad, but laws that discriminate between the sexes are not. And my position, I think that's a good place for sex discrimination complaint evaluations to be. I think it should be perfectly legitimate to say that it's bad to discriminate against one sex or the other, but it's okay to discriminate between the sexes under certain circumstances because the sexes are different for reasons that matter under certain circumstances. Now, the ACLU wants the word transgender to be legally classified as a quasi-suspect class for equal protection purposes. If that happens, that will mean that quote unquote transgender will deserve the same level of scrutiny by courts. The Supreme Court didn't actually get around to deciding that women deserve our own category until 1971. And it's great that they did that, but it took a long time for the Supreme Court to decide that women deserve equal protection of the laws. And now the ACLU essentially wants to co-opt that and make, quote unquote, transgender a protected category similar to sex. And I don't want it to succeed in that. The ACLU, if it doesn't get what it wants by making transgender a protected class, it still wants the Supreme Court to rule that these very important laws constitute sex discrimination, which I hope the Supreme Court does not do. And yes, the ACLU also wants the Supreme Court to rule that sex includes, quote unquote, gender identity under Title IX. In order to do that, it is very likely to rely on a case that we'll get into in more detail, which is called Bostock versus Clayton County from 2020. It's important.
Okay, go ahead.
Well, I just wanted to end that by saying it's important to understand that because the Little versus Hecox case involves an adult man who calls himself a woman and has evidently suppressed some testosterone, but B.P.J. is a minor teenage boy who has had his puberty blocked. The ACLU in the Hecox case, the Idaho case, it has to get up before the Supreme Court and it has to say, we, the ACLU, are arguing to 9 U.S. Supreme Court justices that men are women if they say they are. That's really what their argument has to boil down to. And they really don't want to have to do that, but they've backed themselves into the corner of having to do that. But in the B.P.J. case, the West Virginia case, it has the flexibility of at least making the argument that male athletes who have had their puberty blocked don't have male advantage over female athletes. That's a bad argument, but it's a slightly less bad argument than the argument it has to make in the Idaho case.
Okay, am I correct? And we're going to go to Mariah Burton Nelson next, but for this, am I correct in understanding, certainly in the past, the ACLU has said in the past, oh, these laws are going to require genital inspections to determine who a man and a woman is. Is that, I mean, Mariah, that's a bunch of bullshit, right? That is absolute bullshit. And I don't know if the ACLU is going to actually have the gall to say that on Tuesday, but tell us why this is bullshit.
Okay,
Mariah,
sure.
Mariah Burton Nelson.
Hi, Lisa. Sorry for the technical difficulties. Well, there were such things in the 1960s. And yes, I do expect them to say it. And we know the Democrats have put up signs in Congress saying this will lead to genital inspection. So it's a popular scare tactic these days. In the 1960s, 60 years ago, there were nude parades of female athletes to prove that they were indeed females. Of course, the women found it humiliating and infuriating, and it stopped then. But it's a scare tactic because it works, because then everybody starts thinking about genitals and shame, and then you're no longer thinking about boys trying to claim access, a fair access to female sports. I think of it like the misdirection that magicians use, where they start, directing your attention elsewhere while they're doing this manipulative sort of trick. But they're not actually, there will be no genital inspections. There are just cheek swabs that are increasingly being proposed by international organizations for elite athletes, not for children. A cheek swab is a Q-tip sort of thing, swabbed inside the cheek. It's a little bit like a COVID test, but that was up the nose, more uncomfortable, and there's nothing invasive about it. The other misdirection part of it is they're trying to act like they are thinking about and caring about all women by saying, oh, this is going to hurt all women, not just the boys that they call trans women. But they're not concerned about women. If they were, they would be listening to us.
And when you say cheek swab, we should just let people know as well that still today in the Olympics or in all kinds of competitions, it has been the case that something that is more invasive is simply to check for doping. So you have to basically pee in a cup, is my understanding. You have to go and you pee, and someone has to watch you pee so that you're not putting somebody else's urine in your sample. And that is still going on. And that certainly is more invasive than a cheek swab, right?
That's right. They have to watch the urine coming out of your body. So it's very invasive in that sense. And yet female athletes concerned about doping want it. They say, go ahead, drug test me to be sure that nobody else who has been taking testosterone or other performance enhancing drugs is competing against me or other women. So they're willing to do that. But this whole other thing is, just a scare tactic.
Okay, so I'm just going to state outright again, there is not going to be any genital inspection. That's a bullshit argument. So if the ACLU makes it, it's flat out false. So that makes me wonder, why in God's name make such an argument when it can be so easily disproven? Let's go to Glenna Goldis. Why would the ACLU even say such a thing?
Well, I have good news and bad news about what's going on in the lawsuits with the genital swabs. So the bad news is that cheek swabs do not make an appearance in the briefs for the states. But the good news is that the whole topic seems to have fallen out of the principal brief. So the ACLU is not making genital inspections the centerpiece of their argument before the Supreme Court. But that said, I think it could come up in oral argument, and it's kind of an interesting story of how that has been working its way through the court. So I can talk about that. So this really comes out of the Idaho case, because again, the statutes are written differently. And the Idaho statute says for verification that students can have a healthcare provider verify their sex as part of a routine sports physical exam, relying on one of the following. So 3 different ways that a doctor can figure out their own patient's sex. In case they needed instructions from a statute, here it is. They can consider reproductive anatomy, genetics, or testosterone levels, endogenously produced. So Idaho just wants the doctors to tell the schools like what sex their own patient is. And you would think you think doctors would want to know their patient's sex, and that, in the United States, our doctors would have the skill and ability to do that. Sometimes that's been an issue in developing world countries, like we have the Lisa Simione situation, but in the United States, doctors all have the technology to figure out their own patient's sex. It's important. And so that's what Idaho wants them to do, is like just give them a doctor's note. And the ACLU has argued that's not so simple. So they try to complicate this, and they have all their usual sophistry about why that won't work. They say that, so they try to make it sound like, there are doctors out there who don't know their patient's sex and can't possibly figure it out unless they do a genital inspection, which looks at not just the external genitals, but actually goes in and looks for ovaries. So it requires a probe. So this is like ridiculous, but this is the position that they've been pushing. Although the ACLU pushed it from the beginning, from when they first filed the lawsuits, they seem to, the argument was made by others before that, like Democratic politicians in Idaho. So, it has this illustrious history. And this was back in 2020 when they first filed the lawsuit.
Okay, somebody was going to jump in. Who was it, Glenna or Mariah?
Yeah, just that people should know that this is already in place about the doctors filling out a form indicating that they have done a physical for a student who wants to play sports. In America, that is standard. And as part of that, they say they have checked their heart, they have a healthy heart, they have healthy lungs, there's no reason they can't run around on the field or swim, and they are male or female. These are pediatricians when this first happens, if kids are young, and generally even a teenager will still have a pediatrician. So they have often tracked these same children from birth, or at least when they were very young. So there's nothing unusual about a doctor determining what sex a child is.
Okay, that's Mariah Burton Nelson. And before that, we heard Glenna Goldis. So we've put that to rest. But here's something else that strikes me as I just don't understand what's going on here. The ACLU apparently wanted the Supreme Court to dismiss the Hecox case, right, Kara? Kara Dansky. I mean, why? I don't understand. Why did the ACLU want the Supreme Court to dismiss the Hecox case, number one? And number two, why, if that's the case, did the justices decide to go ahead and say, okay, we're going to hear it? Kara Dansky.
So again, this complaint was brought within weeks of Idaho enacting a law. And again, the Idaho law protecting female-only sports was the first in the country in March of 2020. The ACLU was prepared within weeks of the law being enacted and signed into law. It was ready with a complaint on behalf of a young adult male. Lindsay Hecox was 19 at the time. Lindsay Hecox is a male who calls himself a woman, and the ACLU was ready to file the complaint within weeks of the law being enacted and signed into law. That was nearly 5.5 years ago. Then later in 2020, the lowest court, the district court, agreed with the ACLU and with Lindsay Hecox. Then the state of Idaho appealed to the appellate court, which in that case is the Ninth Circuit Court of Appeals. And for 4 very long years, the case went back and forth between the district court and the Ninth Circuit. At one point, Lindsay Hecox had dropped out of school entirely, and there was a conversation about whether the case was moot because Lindsay Hecox wasn't even in school competing in women's sports, and the ACLU maintained that the case was not moot for years. This case has been going on for a very long time. Finally, at the end of 2024, the Ninth Circuit decided in Hecox's favor, decided that Lindsay Hecox has a constitutional right to compete in women's sports because he says he's a woman and because he has taken some steps to suppress testosterone. Then the state of Idaho asked the Supreme Court to get involved. The group Women's Declaration International USA filed a brief in the United States Supreme Court asking the court to take the case in support. WDI USA filed in support of Idaho, encouraging the court to take the case. WDI USA was not alone. There were hundreds of briefs filed in this case on both sides of whether the Supreme Court should take this case. The Supreme Court had to read some of those briefs. I don't know. I know that Justice Cypher has opinions about whether courts read friend of the court briefs, and I hope she shares them. But a lot of time and money has been spent on this case by the district court, by lawyers in the district court, by the appellate court, by lawyers in the appellate court, by friend of the court organizations. Eventually, after considering the matter, I assume carefully, the justices on the Supreme Court in the summer of 2025 decided to take the case. Then in September, the ACLU decided, oh, sorry, never mind. Please forget everything we've been saying for the past 5.5 years, and please dismiss this entire case. The ACLU attempted to dismiss Lindsay Hecox's original complaint in the district court but the district court struck that down and said, no, you can't do that. And the state of Idaho filed a brief in the Supreme Court saying, no, sorry, you can't litigate a case for 5 years and then say, oh, sorry, never mind, we didn't mean it. We would like all of this to go away. You can't do that. The Supreme Court, as you indicated, has said that it will decide the ACLU's mootness motion after oral arguments. I think it is extremely unlikely that the Supreme Court will dismiss this after 5.5 years, after countless hours and dollars have been spent litigating this case where a male athlete simply decided that he's a woman and he therefore gets to compete in women's sports. The reason the ACLU states that it wants the case to go away is that Lindsay Hecox no longer wishes to compete in women's sports. There are legal reasons why that's a bad argument. But
well, you mentioned Justice Cypher, Elspeth Cypher, who's also
Yes.
one of our guests. So let me ask you, Justice Cypher, is it unusual for the court to hear a case when the plaintiff himself says, hey, drop it, I'm not interested? I mean, is that unusual? Has that happened? Does that ever happen?
It does happen. It does happen, but they don't usually do it. We certainly didn't do it if it was not an important case. If it was an important case and we had a lengthy list of all of these amicus briefs, and everybody, the lawyers and on both sides were well versed in it. The lower courts had gone through a lot. 5 years of time was invested in this. It's not something you're going to walk away from lightly. And so I think it's because it did tie in also with B.P.J. They're the same, they're similar issues. So yes, definitely it's unusual, but not unheard of. And I would say you would not keep going with it until if it was some really incidental, silly case or some case where maybe a settlement had come together. Like if it's a commercial case and the plaintiff and the defendant settle, well, yeah, then you don't hear it because it truly is moot. But in these circumstances, we know that this case is very important to many, 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 many people, if not the entire United States. And so it's not unusual that they kept it. If only, I'm not saying they're doing this, but I might do this if I were in their shoes and I had spent time on this in a conference with the other justices, saying, should we take this case or that case, this case or that case? Because when they vote to take a case, they're giving up valuable real estate on their docket to that case. But so you bet I would make the lawyers come in on this. Because I just wanted to hear it. And whether it's not, and when you say mootness, a court is moot if there's nothing in a case is moot if nothing is in controversy. And courts don't like to vote or decide hypothetical questions. In fact, they won't. But this is not truly moot as to all the other athletes situated like the plaintiffs or the women in these cases. So I think that it's not truly a moot case because there are other people who are in the same position, either male athletes or female athletes, and they want an answer. So I don't think it's that unusual. But what also is another factor you consider in this when you're deciding mootness is whether it's an issue that is likely to repeat. Will it come up again? You bet this one will. Is it likely to repeat, and is it likely to evade review? And it is likely to evade review because this takes so long and these kids grow up, or this guy changed his feelings, and that's what we're basically talking about in this, but that's not legal, never mind.
Well, is that also Is that also why these are being heard consecutively? They're both being heard on the same day. First, the Hecox case, Little versus Hecox, then West Virginia versus B.P.J. Because they're so similar. Is that why they're both on the same day?
Absolutely, absolutely. It's not unusual to pair cases. It's very efficient for judicial resources and for lawyer resources. It's also, you can imagine, they have a lot of cases to go through and read. And if you've got two cases around the same issue, you want to get as much of a perspective as you can. So you want to put them together. That way the litigants can hear the argument before they take their turn. And it saves on time, it saves on resources, and it also shows you, like, one case may show you one side, and another case may show you some other little facts or things that you wouldn't know. So you'd like to get that out there, and pair them when they're the same issue. Also, it's the process of writing opinions is so long sometimes, and there's a lot of back and forth of drafts. And then if you did these separately, you could have this one running in January and another one running in April. And by the time you get around to writing the April case, whoops, guess what? You don't remember what you've done, and now you have a problem in that you have internal inconsistencies. So this also is good for the law because it keeps them from issuing inconsistent opinions.
Okay, that was Justice Elspeth Cypher. Let's go back to Mariah Burton Nelson, our athlete on the panel. Okay, we've talked now about Lindsay Hecox, a male, a boy.
I'm sorry,
the plaintiff.
Lisa,
Yes.
I'm sorry.
Go ahead.
I just want to add to what Justice Cypher said before you go on.
This is Kara Dansky, everyone. Go ahead.
Thank
Kara.
you. I just want to add to what Justice Cypher was saying. So the Idaho case before the Supreme Court comes out of the Ninth Circuit. That's because Idaho is in the Ninth Circuit. Also in the Ninth Circuit are California, Oregon, and Washington. And so to Justice Cypher's point that this is likely to come up again, it absolutely is, because California, Oregon, and Washington are some of the most egregious states allowing male athletes to compete in women's sports. And I just wanted to circle back to your question, Lisa, before you go on to Mariah. The reason the ACLU wants this case to go away is that it knows that it's going to have to stand up before 9 justices of the Supreme Court and say that a man is a woman if he says so. And it doesn't want to have to do that because it knows it's going to lose.
Well, let's hope that there's some common sense there. I don't know how three of the justices are going to say anything about that. We'll get to that later about what your predictions are. Mariah, Lindsay Hecox was a college student. We've already gone over that, an adult male. But in the other case, in West Virginia versus B.P.J., which stands for Becky Pepper Jackson, Becky, so-called Becky Pepper Jackson, is also a boy, but he was a teenage boy who had his puberty blocked. So people are saying, like ACLU are saying, look, he had his puberty blocked, so he's no stronger than any of the girls. Why can't he compete with the girls? What do you say to that? Would he still have an advantage over the girls?
Yes, he would. And also, he's not a girl. The female category is because males have advantages with height, strength, speed, bigger hearts, bigger lungs, bigger skeletons, bigger heads, bigger hands. A lot of those things are not affected by puberty blockers. When you think about what a puberty blocker does to a boy, it medically or surgically castrates him and it weakens him. It damages or destroys his sexual and reproductive functioning, and it will make him weaker relative to other men, which should be the comparison. If he wants to make a case that he's now weaker, he's weaker than men. But that does not mean he is a woman, and it's so insulting. And I'm sure a lot of women on this call will appreciate my perspective on this. That's not who we are. We're not men minus testosterone or men minus their puberty. Medical science, unfortunately, is really creating a whole new category of disability. These are disabled men, and someday, unfortunately, there might be enough of them to qualify for their own Paralympic kind of category of puberty-blocked males. And unfortunately, they are being sold a bill of goods and told that this will make them a woman. But they will never menstruate. They will never give birth. They will never have a C-section and have to recover from that. They will never nurse. All of these things obviously have an impact on athletic performance. Our bodies are designed to do those things. There are two sexes because of reproductive differences. So yeah, they're not girls. And there's there's enough of them now that they have done research on how their strength and other measures of athletic performance compare to girls and women their ages. And there's a leading trans-identified researcher who was actually very influential with the International Olympic Committee. This man's name is Joanna Harper, a physician. And even Joanna Harper now has done research trying to prove that these puberty-blocked males are just as weak as females, which is not how I would phrase it, but that's what they're looking for. And Dr. Harper has concluded, no, these men still have advantages.
You know what kills me? We're hearing all the time now about boys and men who want to compete with girls and women because, oh my God, if they don't, they're going to go through such terrible mental and emotional distress. This is going to ruin their lives, these poor people. How come we don't hear about girls and women saying, gee, I want to compete. I want to pretend I'm a man. I want to compete on the men's team. We're not hearing that. Why aren't they experiencing all this horrible distress that supposedly these boys are experiencing? I mean, I think we know the answer to that. I think it's pretty obvious, but why don't you tell us?
Sure. Well, they're not even trying to do that, to compete against men, because they know they would not have a fair competition. You know, as an athlete, it's not really about winning. It's about competing against people who are similar to you so you can challenge each other on a fair basis. That's why we group by age and weight sometimes, disability, as well as sex. So yeah, they're not these young women who call themselves men or call themselves non-binary. They don't want to compete against men, and they don't. They almost never do, because they do understand, ironically, the differences between the sexes, the immutable differences between the sexes. So then what happens is they just compete against women, and they call themselves trans, or non-binary, or both. There's one in the WNBA right now. She had her breasts removed. Lashia Clarendon is her name. Nikki Hiltz was in the Olympics, a woman who says she's non-binary, that she says this is a very big deal. I'm the first non-binary woman to run track in the Olympics. Great, fine, but it's just a woman, and she's running in the women's category because she could never do well against the men.
And I think many of us remember that during the Cold War, East Germany, I mean, I can still see the images from the TV in my head. East Germany would pump up its female athletes with steroids and testosterone to give them an advantage over other women. And that's basically doping.
Yeah.
So I mean, competing against a so-called trans, I don't even know what to call them anymore, a man who pretends he's a woman, competing against a man who pretends he's a woman, isn't that like competing against a woman who's doping or somebody who's doping?
These terms are so hard. No, if a woman takes testosterone, she's not eligible to compete against women. That would be doping. And if she tries then to compete against men, which, as I said, they never do, she still won't do well. Even a woman plus testosterone cannot compete on an equal basis with men who are at her same level, high school, college, elite, Olympic, whatever her level is. No, we can't take enough testosterone to match men's testosterone or to mimic what men do go through during puberty.
Okay, let's get back to the Supreme Court cases. Glenna Goldis, with all of these questions involving people who say they're quote unquote transgender, everything boils down to is they claim they have this inner essence, this being, this soul that is, quote, a gender identity that should take precedence over the material reality of sex. Do you think the court will weigh in on this?
The court has been treating the question of gender identity superficially, even though it's vitally important. And my best guess is that it will continue to do that in this case. So just it's a brief history because they've only had pretty much 2 big cases focused on gender identity. The first, like we've talked about, was Bostock, decided in 2020. And that was about the man who wanted to, quote, live as a woman at work. Was not clear about what that meant. But there, the court just did not use the term gender identity in the majority opinion. They talked about this person's transgender status, and they did not define what that was at all. They just treated it like a given, like we're all supposed to know what it is. So that was 2020. And then in Skermeti last year, they used the term gender identity, Justice Roberts in his majority opinion, but he did not analyze it or give it a definition. But all that being said, they have been pretty clear that sex in their mind means physical characteristics. So they use the term physical distinctions. And then they imply that gender identity is like the non-physical stuff, I guess. It's like, that ghost you were talking about. I wish they would look at it a little more closely because gender identity is worse than a ghost in the ACLU's cases. Gender identity is actually just like a jumble of words that contradict each other. It has no logical meaning whatsoever. It's completely empty. It's null set. So if the Supreme Court saw that, then they would get to their conclusions a lot faster. But anyway, they're treating it as like something kind of ethereal that is not sex, what that people are talking about. And I guess they'll probably do that here.
Okay, so just so I understand, in the Bostock case, it was a man who says he was a woman, but is it that he just did not want to be discriminated against? Like he didn't want to lose his job? Is that what that was about? He wasn't saying he should go into the women's restroom, right?
Well, also, yeah, so restrooms is an interesting question. They avoided demanding restroom access, and the court explicitly said in the opinion that we're not talking about bathroom access. So then it's like, okay, what are you talking about? Not clear. They didn't say, oh, we mean that the employer has to use she, her pronouns for this man. No, they didn't say that. They didn't say the employer has to let him wear a dress. That's kind of implied, but they don't say that either. The term they use is being transgender. So what's protected is being transgender. We have no idea what that means, except that it doesn't relate to bathrooms.
Oh my God, if we don't know what it means, how can they even argue if we can't define our terms? If I can't say a bottle is a bottle and a pencil is a pencil, I don't understand how they can argue these cases. I don't know. Kara, do you want to jump in here? I don't really understand. Can they say something different that will contradict what they said in Bostock or what?
So Bostock is a complete mess. And the Supreme Court is really in a bind here. Part of the reason it's in such a bind is that the case that eventually became Bostock in 2020 started out as 3 separate cases. In 2 of the cases, there were gay men who were fired for being gay, and that wasn't even in dispute. So part of the outcome of Bostock is that discriminating against gay people in the employment context is unlawful under federal law. It's called Title VII. That's the federal law that governs employment discrimination. You're not allowed to discriminate against people for being gay in employment. I would argue that that's a good outcome, although I don't think it was necessary because I could make an argument that that was already the case. But in any event, the third case involved was a man who called himself Amy. He called himself a woman named Amy. And yes, he was demanding to be able to use the women's bathroom at his place of employment. And he was demanding to be referred to as Ms. Stevens and using she and her pronouns in his place of employment. And he was eventually let go. I don't know the circumstances of that. But yeah, the Supreme Court, in a majority opinion written by Justice Gorsuch, said that discriminating against people in employment on the basis of their sexual orientation or their quote unquote transgender status violates Title VII. And as Glenna said, it did not tell us what it meant by transgender status. It just said it It just assumed that we all know and agree what it means. But of course, we don't. And then something even worse happened because, as Glenna said, the Bostock decision is bad because it protected transgender status in employment without defining it. But one thing it did not do is say that sex includes quote unquote gender identity. I promise I've read the opinion over and over and over again to see if the Supreme Court said that sex includes gender identity, and it didn't. Another thing the Supreme Court did, as Glenna said, was explicitly limit the reach of the decision to employment. However, in a dissenting opinion, Justice Alito said, and I'm paraphrasing, but I've got it pretty close. He said, the federal judiciary will be mired for years in litigation about the reach of this court's decision. And he was 8,000% right, because in January of 2021, the Biden administration issued Executive Order 13988, this famous Biden executive order that effectively erased women and girls as a category. It erased sex as a category under federal administrative law, and it did so by falsely relying on Bostock. Joe Biden said on the first day of taking office and throughout the rest of his administration that the Supreme Court said in Bostock that sex includes gender identity, which it did not. And Biden ordered federal agencies to redefine the word sex throughout all of federal administrative law to include so-called gender identity, and federal agencies spent all of 2021 doing exactly that, culminating in the 2024 Department of Education announcement that sex includes so-called gender identity under Title IX. And the Biden administration said that the reasoning of Bostock applies outside the employment context, even though the Supreme Court explicitly said in Bostock that it wasn't doing that. So it's a disaster.
So do you think on Tuesday they might just clarify this once and for all? Sex means sex. It's not whatever idea you have about yourself.
So on Tuesday, all they're going to do is ask a bunch of questions. They're not going to decide anything on Tuesday.
Oh, in the springtime. Yeah, sorry. The decision comes in the spring, right? Okay. Let's, Elspeth Cypher, Justice Cypher, tell me what you're going to be listening for from the justices. Like, are there certain words or key phrases or lines of questioning that might give us a hint about what they think?
Sure. And I really appreciate what Glenna and Kara just said, because they really put this in perspective when you go back to Bostock and you realize what trouble you're in from that case. And just as a point of what I read was that the plaintiff or the transgender status person worked in a funeral home and wanted to come in the next day wearing women's clothing. And the funeral manager thought, that is not going to go over well with my clients, with grieving people. So he fired him, or he said, no, you can't come in a dress. And that was it. But I'm going to be listening in particular to their language. I think as this issue has evolved over time, it's really clear to me one of the most important points for us in this legal battle is language, because so often you see justices or judges just adopt trans speaking language, cis woman or trans woman, and they adopt the pronouns. In one case that Wolf has been involved in, we have there's a rape victim, two rape victims who were raped by a male prisoner who was saying he is a woman, and the judge has ruled, even though he's impregnated women in other prisons, that he must be referred to as she. And that's just, we're just really upset about what these women are supposed to do in that case. So I'm going to be listening to the language. Are they using reality-based language, sex-based language, or are they using trans-based language? Because that is going to tell me, number one, well, if they use trans language, it doesn't tell me much. But if they use sex-based language, it tells me they are paying attention to the real issue here, which is sex as a separate category that is biologically based and doesn't change. If they start using trans language, I think it's gonna be a little mushy. I would also, in addition to listening to the language, and they all might use different language, I don't know. I'm going to listen for words like equal protection. And in particular, there's an argument floating around that equal protection only applies to African Americans because that's only who they were targeting with the amendment, because that was who was suffering from gross discrimination based on the color of their skin and their race and their former slaves, maybe their former slave status. So it was going toward Jim Crow laws. So I'll be listening for that. Is anybody going to try to bring it back to that basic point? If it does, we have a lot to worry about in the future. I'm also going to listen to states for the word state rights, states' right, the right of the state. That is what they did in Dobbs, which reversed Roe versus Wade. They said this is just for state rights. You get to do this, state rights. And interestingly, if you look at legislation that has come out of the trans activist groups, a lot of it always ties bodily autonomy for trans people back to abortion, which was a strategy that was recommended to them by Denton's law firm, that if you have an unpopular idea, be quiet about it and append it to a popular issue. So that's what they did. So Dobbs went on state rights, and so did Skrmetti go on state rights. They could just go on state rights here too and say, yeah, the states can decide this. And then the final category of language I'm going to be listening closely to is level of scrutiny. Is any one of them interested in discussing whether transgender status should receive intermediate scrutiny like women do? And will any of them recognize that if they do that, they'll have another continuing clash of rights? So listen for levels of scrutiny. Think of it like a pyramid, strict scrutiny at the top, intermediate in the middle, and then rational basis in the bottom. And as you climb the pyramid, it gets harder and harder to, to get a law through that could arguably violate equal protection. So that's what I'm going to listen for.
And Glenna Goldis, what about you? Would you agree with those things? Do you have other things you're going to be listening for?
I agree with those points, with the caveat that I think we will hear some conservative justices use the language of the ACLU to some extent, but that's not necessarily a cause for concern. So Justice Barrett in particular has a style of questioning where she just kind of gets into the mind of the person she's talking to in order to converse with them, and to that's how she gets the points across, and it's kind of like, okay, well, assuming everything you're saying is true, let's just go with that. Sure, I'll pretend, whatever. And we've even seen her do that specifically with trans, where she'll use terms like cisgender. But then in Skrmetti, she wrote a very strong concurrence, one of the strongest. So I think we might hear language from her that's kind of silly, but doesn't mean anything. Justice Alito last year used the term gender fluidity with a straight face, and half the internet exploded with rage. But he was only doing it in order to lure Chase Strangio into his trap.
And Chase Strangio is the ACLU lawyer,
Yes.
the woman who presents herself as a man.
Yes. So that's an example of how justices can sort of play devil's advocate, or use the person's language against them. So don't freak out if you hear that. And likewise, you might hear something good from one of the justices on the other side, but just wait. Even sophisticated court watchers sometimes fall for this, where they get overly invested in the language that a justice uses, and then they get surprised later on. So
Okay.
other points, I'm excited to hear how the liberal justices respond to the Solicitor General when I assume he will use proper sex-based language because he's required to as federal policy now. And I don't think you can really easily avoid it in a case like this. So when he's calling the so-called trans girls boys, will the liberal justices start spluttering at them, as I think many of us have seen happen in our everyday lives with people who prefer that language? So I'm curious about that. And I'm curious to see how Justice Thomas asks questions, because he's been very strong in the past on trans. He, for example, in Skermeti, he was asking about physical harms and like really drilling down on that, which is a subject, it is like the subject that trans activists don't want to talk about. And he wrote a strong concurrence. So again, he's the one I'm watching for like exciting questions. And luckily he will go, I think, second in order because of his seniority when he's asked questions. So that's something to look forward to.
Okay, Kara Dansky, what about you? What will you be listening for?
So just getting back to Bostock briefly, I just think the Supreme Court is in a real bind about what to do about it. And Justice Gorsuch was the author of the majority opinion in that case, and it has to deal with it in one way or another. So I'm curious to see if any of the conservative justices ask the state lawyers, the Solicitor Generals for Idaho and West Virginia, for advice on how to handle that. WDI USA, in its briefs in these cases, has encouraged the court to come out with some kind of clarification that what it meant by transgender status was something along the lines of nonconformity with sex stereotypes in employment. Because I would love it if they overruled Bostock, but they're not going to do that. But somehow they have to clean up the mess they made in Bostock. And then I will just say that, elaborating on what Justice Cypher said, I want an explicit decision in this case that quote unquote trans is not a quasi-suspect class for equal protection purposes. We know from Skermeti that Justices Barrett, Thomas, and Alito are ready to go there. We don't know about Justices Gorsuch or Roberts, but that's what I want. So I'm going to be listening carefully to any questions from the justices that suggest something about whether a majority is ready to go there.
Okay, I had mentioned we don't expect a decision until the spring, probably June. So I don't know if this is fair to ask you. We're going to do a round robin again. I don't know if it's fair, but let me just ask, do you have any predictions about what the court might do? Let's go with Elspeth Cypher, Justice Cypher first.
Thank you. I don't have a prediction, but I have a hope. And my secret fantasy, it's not a secret really, is that, as Kara said, Justice Comey Barrett, she wrote a great concurrence in Skermeti. So in my world, Justice Comey Barrett is assigned the case to write the majority, and she does it very clearly using the law appropriately and points out that no, this is not an immutable characteristic, which is what is required for an equal protection claim, because you can change your gender and there's gender fluidity. So no, it's not appropriate for an equal protection analysis. So I'm hoping she does it. I don't know where Justice Kavanaugh is. I agree with everyone that you've got the three liberal women, the one, and then you've got Barrett and Thomas kind of really getting it, and Alito really getting it. But I don't know what would happen if you had Roberts, Gorsuch, and Kavanaugh promoting some kind of moderate compromise, which I hope doesn't happen.
We've become very used to 6-3 decisions. I mean,
Yes.
likely to happen here?
It could, yeah, sure.
Okay, what about Glenna Goldis? What do you think? Any hopes, predictions, any thoughts about that?
Yeah, well, you all know what I hope will happen. I think that so I think this kind of breaks down, if you take the legalese out of it, there's two issues. There's self-ID, like can a man just say he's a woman and therefore play on the women's team? ACLU is abandoning that, like not explicitly, but pretty much. So I think that we're going to get a good win on that self-ID. But then the other question is, what about these boys on puberty blockers who supposedly don't have an advantage? Now, I know you're all saying he does have an advantage, whatever, and we've talked about that here. But the fact is that the record before the court is really sparse. It was litigated several years ago in West Virginia, and it's been slowly winding its way through the courts. And so there are a lot of studies that we like, which are not on the record. So if there's some kind of compromise thing going on, or if the justices are genuinely confused, then I think they could kick it back down to the district court and say, like, well, you need to get to the bottom of these studies and find out if there is an advantage. I can see a world where they even have a reasonable idea of what sex is, but there's still a possibility of boys not having an advantage and therefore discrimination not happening if he is puberty blocked. And I know everyone might be mad at me and say, yes, but I'm just saying, like, that's a possible stupid compromise we could see coming down the pike. But the good news is I don't think the compromise would become law immediately. I think it would just look like dragging things out for a couple more years by sending it back to the district court.
And Kara Dansky. Kara, what about you? Your turn. Hopes, predictions, thoughts on what their decision will be?
Well, in terms of hopes, as Justice Cypher said, what I want, and I'm not going to get it, but what I want is a 7-2 majority with Justice Kagan in the majority ruling conclusively that trans is not a protected category. I'm not going to get that. That's what I want. Yeah, and a compromise by Chief Justice Roberts and Kavanaugh and Gorsuch, I think, is likely. That'll be a bummer. But as long as it's a majority upholding the legality and constitutionality of these laws, I can live with that. Sadly, I think Glenna is probably right that there's some reasonable chance that we will have a win in the Idaho case, which is purely about male self-ID, and the court will kick it back for further consideration in the B.P.J. case. One thing we haven't talked about at all, though, and I just want to raise it, I know you want to go to questions. One thing that has come out in briefing is that this minor male, B.P.J., he was 11 when the case was filed. He's 15 now. He has been brutally and disgustingly sexually harassing female athletes on his team. And that is now public knowledge. A young woman, I'm forgetting her full name, but she goes by AC in court documents. She has said publicly the kinds of things he has said to her and to other girls. And the justices on the Supreme Court know that. It's utterly disgusting stuff. And it will be very interesting to see how the female liberal justices deal with that. Like, I don't know. How are they going to deal with that? He has said horrible things.
Allegedly, this is what she alleges. So maybe they'll just skip over it because it's not been proven. Is that it? They'll say, well, he allegedly said these things.
Right. The ACLU has denied that it happened, but AC has reported that they happened under penalty of perjury. And so how far is the ACLU going to take that? How far is the ACLU going to say, don't believe this girl, forget about Me Too, don't believe this girl who has said these things under oath and under penalty of perjury? Are they really going to do that? Are they going to, they have said, they have denied the allegations, but how far are they going to deny the allegations? And what do the female liberal justices on the court think of that? I don't know. I'm curious.
Okay, before we go to questions, which we're gonna do, audience, in just a minute, I would like to end with Mariah, who's our resident athlete and women's sports writer. This is, Mariah, you know, we get this all the time. We get people saying, why do you care about this? It's such a fringe issue. It's such a minor thing. There's like, how many athletes are we even talking about around the country? How can this possibly affect girls' sports? It must be just a handful. We get this crap all the time, as if, I don't know what the magic number is. So if only 5 boys hurt 5 girls on the women's team or take their honors and opportunities, that's okay. But if it's 20, it's not okay. Or if it's 50, it's not. I don't know how it's illogical, but we get this shit all the time. So I want to hear from you that actually it's, how many are there? What are we talking about here nationally?
I do have those numbers and I understand the question. Before I answer it, let me just add to what Kara said, that the context for the sexual harassment was the locker room. So this is a boy who's being allowed into the girls' locker room. So they're standing there with nowhere else to go. They need to change their clothes in front of him or hide behind some shower curtain while trying to protect their privacy. And that is where he is saying vulgar things about his own body parts and their body parts. So that's part of the problem. And nobody's asking what I want to see. And that's fine, Lisa. But I would love it if they would roll locker rooms into their decision and say, yeah, no boys in locker rooms either, period. But as for the number of males, I mean, or number of transgender athletes, and yeah, who does it harm? And it doesn't really matter. I understand that people are curious, and I was curious myself when I got involved in this. Well, what are the numbers? What are we talking about? And so the answer to that, as tracked by an anonymous, diligent researcher at hecheated.org, the ones that she has found through her research, which does not constitute all of the males in the United States, even at all different levels, all different sports, she has found 1,200. Now that may sound like a lot, may sound like not very many, but it's really the wrong question to ask. You need to ask about the impact. So when one of those 1,200 males competes in women's sports, he doesn't just do it once. That's not how sports work. You don't just go compete once. You compete over and over again through the course of a season or many seasons or many years. So the number of documented races or events with male athletes in them, women's events, is 18,000. So now we're up to 18,000 times where girls and women have lined up next to some boy or man. And of those 18,000 events, the number of top 3 finishes among those boys is 10,000. That's more than half the time when this particular group of people enters races, they win. So that would not be true for any group of girls. It would not be true for girls who have blonde hair or girls who are Jewish or girls who are left-handed or tall or anything else. So that in itself shows you that they have an advantage, which we already know. And beyond the college and high school levels, they're stealing our money. And that number is $2.5 million so far, and all of these numbers keep rising, and I'm checking them over time. They keep rising. That's
And when you say stealing our money, women's money, you mean from prizes?
Yes, prize money. Yep, that's prize money. And then scholarship money, I don't think is rolled into that, but there have been scholarships, a few at the college level as well. So the calculation that we came up with is when you take one male runner or swimmer over a 4-year high school career, for instance, he is going to impact 250 girls between the girls on his team, the girls on the other teams. And then that's leaving it. So if anytime you hear about one male, multiply it by about 250 roughly. It all depends on how many, how big the sport is and how many competitions he's really in. That varies by sport, but it's a good round number to use. And then that's not even counting the girls who feel discouraged, who aren't even playing sports anymore. And we are hearing about them because they're reading or hearing about the controversy. They don't want to deal with it. Or the girls who drop out, or the girls who keep playing and lose or don't score as high as they should and feel very discouraged and very demoralized by the adults allowing this. And fortunately,
Or who are injured. There have been
Yeah.
girls who've been
That
injured.
too, absolutely, yeah.
Okay, let me just ask,
I'll just say they're
are these
standing up for
not-
themselves. I love it that these girls are standing up for themselves and speaking out increasingly and saying, this isn't fair, we're not doing it.
And these numbers, the statistics that you've just cited, Mariah, are these in an amicus brief that has been filed so the court will be able to see these things? Does anybody know? Kara, Glenna, Elspeth, anybody?
I don't know about the numbers, but I know we submitted all of B.P.J's nasty comments in our brief.
Mhm.
I have to go ahead.
WGI USA included some of the numbers in its brief.
Okay, so presumably the justices will see this.
I mean,
I think yes. I think that what happens with cases like this that are so important and that have such a huge record, the justices obviously can't read every single brief. But what will happen is that on that court, the law clerks some law clerks will divide it up. Some law clerks will work together. Some won't. But or staff attorneys too, they'll be reading those things. And when they find things of relevance, they will forward them to the judge and point them out.
I really have to just jump in here and say, I find this an infuriating and frankly, totally illogical argument to say, well, it's just a handful. Even if it were just a handful, that makes it okay. Yeah. I mean, Peyton McNabb was a female volleyball player who got knocked in the head by a male who's pretending he's a girl, and a concussion. She has neurological and brain damage to this day because of it. So if she were the only one in the country, and she's not the only one, but even if she were, so no big deal. What's the big deal? It only happened to her. This is an infuriating argument. I don't see how anybody can like the ACLU or anybody can say that this is a legit argument. It's shocking to me.
Lisa, I'll just add one more thing. You can't make that argument without being sexist. You don't do that for men. We don't hear that from men. Oh, there's just a few people cheating, doping, using performance-enhancing drugs. Doesn't matter. It's not going to hurt those men. Why should those male Olympians care? So you only hear this when it's just female athletes. It's a way of saying women don't really care about sports. They don't really deserve sports. They shouldn't be so upset. They should just be quiet and let men have what they want.
Wow, it's infuriating. Okay, so I'm going to let the audience get in here. Let's go to audience questions. And my understanding is that Ellie is going to choose the audience, the people who are going to give their questions, not me. So Ellie, take it away.
Okay, I've elevated. Girls are girls. Let's go to you first.
Girls are girls. Your mic is muted. Can you unmute your mic?
I'm sorry. I don't have any questions. That was a mistake. So please ask someone else.
We have another one who I can't pronounce.
Hi, my name is Ilona. Hi everyone. Just wanted to say a huge thank you for hosting this space. And whilst you were discussing males in women's sports, I remember this incident that happened to me. It happened to my friend actually. I used to train Brazilian Jiu-Jitsu, and at some point in summer, I went to Ukraine for a couple of months, and then when I came back, I noticed that she wasn't. She stopped training. And I asked her what happened, and basically at one of the regular group classes, there was an incident where one of the guys, it wasn't like a sexual harassment kind of stuff, but she was wearing a Muslim like a sports hijab. And the guy, what happened was that he started at some point, he was like, she didn't know him. He started pulling onto her sports hijab, like in a really aggressive way. And when she became very distressed and, they had some kind of obviously ended up having a kind of an argument, she gets really angry. The biggest problem was that the male coaches, they didn't even want to hear her. Like they didn't, it wasn't even it wasn't a matter of whether she was right or not. It was a matter of her not even being listened to. And I remember like really enjoying having going to like girls only classes. They were really like, there was a very special sense of sisterhood developed, that developed there. And I cannot imagine those classes being attended by males, regardless of how they identify. There was something about them that would be completely ruined, and they wouldn't. There are certain cultures where girls from them, they are not gonna turn up to the jiu-jitsu class if there are guys there. And that friend of mine, she ended up leaving the school. I was the only person, to my big surprise, I was the only person who walked out from that school together with her. I could not understand, to be honest, I don't understand to this day how the rest of people who were training there pretended like nothing happened. And the school ended up coming out with a public statement accusing her of like inappropriate behavior. And then we joined another school together, and I watched how much that incident that happened like a few months earlier traumatized her. And so the damage that one single incident that's not even necessarily related to sexual violence, it's huge and it's very long lasting. And after seeing her having like just breakdowns in the changing rooms after classes, I realized like how what's a long lasting effect it can have. And so
Well, this goes back to what Mariah Burton Nelson just said a minute ago, which is that girls don't matter. Girls and women don't matter, and we're supposed to just put up with whatever the guys want and defer to them.
Yeah.
Okay. Next.
Hello? Oh, yes. Thank you. I'm from Connecticut, and I'm wondering what impact a positive ruling would have on the blue states.
Who wants to take that? That's a great question. That is a very good question, especially if it goes back to either Kara or Glenna or Elspeth said this might just get thrown back to the states. And so we're going to have a hodgepodge of different laws around the country and not one overarching law. So what happens? What are the blue states going to do? Who wants to take this? Kara, Glenna, Elspeth, anybody?
Well, I can say
Kara Dansky.
Yeah, Leslie, first of all, there's a case that's been pending in your state since 2020 involving 4 high school female athletes who sued their state athletic association for allowing male athletes. And this case has been going on even longer than the Idaho case. And it is so depressing how long it's gone on. The girls were in high school when they sued. They're not only through high school now, some of them are through college. It's just utterly ridiculous. But okay, to answer your question, the only questions before the Supreme Court are whether states may maintain single-sex sports. If the court only answers that narrow question in the affirmative, which I'm hopeful that they will, it still won't say that states must maintain female-only sports. Women's Declaration International USA filed a brief arguing that the court should go further and say that Title IX and the Equal Protection Clause say that states must maintain female-only sports. I think the Supreme Court is unlikely to do that as much as I want it to. But if it says that states like Idaho and West Virginia may maintain female-only sports, that will be a good thing. But states like Connecticut, California, and Washington will be free to go on doing whatever they want. I'd be very happy to hear from other panelists if they think I'm wrong.
Well, I think that we are likely to see a ruling that says sex means sex in Title IX. Like that will come up and the justices will say, yeah, there's no gender identity in that statute, which is, that's the plain reading of the statute. We knew that already, but a lot of the blue states have been clinging to this hope that they can pretend that gender identity is part of Title IX. And this would be shattering the illusion that they've been propping up. which would mean, we already have the Trump administration going after these school districts for discriminating against girls under Title IX. So that's already been happening. And some of these districts and states have been opposing him. California filed a lawsuit against him. So we would see that continue basically, but with Trump's position even stronger and the blue states or the blue districts even weaker in court. And so eventually what that leads to is the federal government is able to pull Title IX funding from the districts or the states. That equals about 10% of a school district's funding on average. So, it won't overnight bankrupt them, but it should be upsetting to the people in the community. They don't want to pay higher taxes to make up for that. They don't want their kids to have worse schools because of that. And so what you might finally see, and you're seeing it a little bit already, and I think Michigan has this happening where towns are speaking up, or people in towns are speaking up and saying, hey, stop fighting the federal government on this. We don't agree with the policy. We want the sports to be sex segregated. We don't want to lose our money. What are you thinking? And we already know how popular our side of this is. And so we'll see more pressure on the blue districts and blue states from the people of America.
Okay, who's next?
We don't have any other requests. Anybody else want to ask a question?
I see one request. I don't know if that's.
Yeah, LM Alcott, speaker, go ahead.
You're on.
My question is, do you think any of the 3 liberal women justices will change their mind once they listen to the arguments?
I can answer that, I think.
This is Elspeth Cypher,
yes,
Justice
sorry.
Cypher.
I don't believe that there's any hope for Justice Jackson or Justice Sotomayor. They sounded too much in with the transgender approach. But I think there is hope for Justice Kagan. So I hope that happens. I really do. Can I just add one thing? It is so heartbreaking as a lawyer and as a state court judge to see the women. I mean, I know it's happened in so many areas, but to see the women justices just go along with this, or for one of them to even say in her hearing that she can't define a woman because she is not a biologist. It's heartbreaking to me to watch this. Do we all think so little of women that we don't recognize what's happening?
Great point. It looks like we have 2 more requests. Is that correct?
Yeah, I just elevated Lee Santos.
Hi. Yes. If the Supreme Court rules that in these 2 cases that the state only rules that the states may protect the female category in sport, what will there be a future case that asks requests that the Supreme Court protect the female sport, in all states? Like what would a case like that look like? When might it arise? When could we expect it to reach the Supreme Court?
Who wants to take that?
So this is
Kara Dansky.
Sure. The reason the cases currently before the court are in the posture that they are is that the 2 states that are applicable here, Idaho and West Virginia, have said schools must maintain single-sex sports. And the challengers are male athletes who want the court to rule no. So it's like, may the states maintain single-sex sports? Yes or no? If a female athlete challenged which has happened in Connecticut. I mean, this is what's so frustrating. Yeah, I don't know if Leslie's still in the space, but in 2019, female athletes in Connecticut filed an administrative complaint against their state athletic association because their state athletic association allowed male athletes to compete. And they said, no, you can't do that. And the case has just gone nowhere for various boring reasons. But if that case ended up before the Supreme Court, the question would be squarely before the Supreme Court: must states maintain single-sex sports? There was another case that happened a million years ago called Boyertown, where a group of students, high school students, mixed sex, girls and boys, their school district, Boyertown School District in Pennsylvania, just enacted a policy over the course of a summer allowing school students to use whatever bathrooms and locker rooms aligned with their gender identities. And a bunch of high school students said, we don't like that. We want single-sex bathrooms and locker rooms. And they lost before the district court. And then the case went to the Third Circuit and they lost again. And they asked the Supreme Court to hear the case. And the Supreme Court was like, no, sorry, we're not going to do that. But had that case gotten before the Supreme Court, that would have presented the very straightforward case or question of, are schools required to maintain single-sex bathrooms and locker rooms? And Women's Liberation Front, on whose board I served at the time, which I no longer do, but Elspeth currently represents as secretary of the board of Wolf, filed an amicus brief, a friend of the court brief, before the Supreme Court and said, hey, Supreme Court, can you please look at this question of whether sex is real and whether high school students have a right to single-sex locker rooms and bathrooms? And the Supreme Court said, no, sorry, we're not going to hear that case right now. Sorry, too bad.
Isn't there just a basic equal protection claim, like for females, for women and girls, that like, you know, like that that being a woman or femalehood is a suspect class. So isn't there just a basic equal protection claim that could be filed in California or one of these blue states that this is violating women's right to equal protection?
Yes, and that's sort of what I'm saying, is that that argument has been put forth, and okay, look, there have been 3 cases, Boyertown, Grimm, and AC versus Martinsville, where the Supreme Court has been asked to look at the equal protection implications of allowing students to use opposite sex bathrooms on the basis of their gender identities. In each of those 3 cases, the Supreme Court just didn't take the case.
Do we have a suspicion that like maybe they just don't think it was ripe, or now that it's a growing issue that might change?
Well, it is changing because they have taken these cases. And it's impossible to speculate about why a court does or doesn't take a case. They're never required to tell us why they did or did not take a case. So we can't really know. I mean, there can be speculation about whether some of the Supreme Court justices, possibly including some of the conservative justices, might have kids or grandkids or nieces and nephews who call themselves transgender. These 9 people are, after all, human beings. They have families and lives and whatnot. So I don't know if that's the case, but, you know, perhaps that could be playing a role. I don't know. But it's really difficult to speculate on why. I mean, I will tell you, I've been really frustrated over the past 10 years at the Supreme Court, but now we've got a shot. And my gut answer to you is yes, there is a very straightforward claim that under the Equal Protection Clause of the 14th Amendment to the United States Constitution, which the Supreme Court did not even recognize applied to women until 1971, when the late Justice Ruth Bader Ginsburg forced the issue, applies to women. And now we're having to hold on to it with our bare hands so that trans doesn't steal it from us. I'm sorry I don't have a more satisfying answer.
No, thank you very much. That was super helpful. Thank you.
Yep.
Riley Gaines' lawsuit made the claim under the Equal Protection Clause, but I think that may have been dismissed on a technicality, that particular claim.
That was Glenna Goldis. I think we have one more before we finish. Is that correct?
Yeah, this is a repeat, and again, I can't say the name. You should be able to speak.
Hi, can you hear me?
Yes.
Yes.
I'm continuously baffled by the situation in the UK where there is a Supreme Court judgment that should by now it should have clarified any outstanding issues, and there is no higher court that the judgment is basically binding on all the courts below it in the hierarchy, right? And is literally being pretty much ignored. There is a guidance that needs to be updated by the Equality and Human Rights Commission, and some people are trying to make it sound as if as if it's all contingent on the commission, but it's that's not the case actually, and it's been really disappointing to see, because there was prior to the judgment in April, there was a lot of hope that finally once if it comes out and it's in in the favor of science and common sense, then finally it's gonna kind of deal with any kind of I don't even know any confusion, right? And still no. And so I think it was last week when in a gym in London, a woman confronted a male in a changing room, and she was accused of harassing him, and now she is banned from 10 gyms in her area by the local council. And I just don't understand how this is has been allowed. And
Kara Dansky can address that directly, because she can explain the difference between the US Supreme Court and the UK Supreme Court. They're two different things. So Kara, can you explain the difference?
I mean, at a cursory level, I can say that the US Supreme Court was established with the ratification of the Constitution in 1787. It's in Article 3 of the Constitution, and it's been a critical institution of United States democracy ever since the founding of the Republic. The UK Supreme Court is a much newer institution. My understanding is that the Supreme Judiciary functions were handled by the House of Lords.
Yeah, that's correct.
Yeah, for the longest time, and that the UK Supreme Court only came into existence in 2009, and that a lot of its opinions are considered advisory, which
I don't know that's not from the legal point of view, I'm trained as a lawyer in the UK, that's not the case. So that decisions are actually, they become binding the moment they come out. And also another thing is that the judgment mentioned that it did not introduce any new law. It merely clarified the existing law as it has always stood. So it acted more like to clarify any confusion if anybody had it, right? So it did not actually introduce any new legal norms. That's why it's really baffling to me that still it's not being followed.
I understand that's what it said. I mean, it's similar to it's baffling that many states in the United States, including California, are just openly defying the president's executive orders. You know, that's just what they do. I think in terms of it being baffling, the easiest way through this is just, we're a little bit off topic now, but the easiest way through this is simply to understand that it is as bad as it seems. Like, nothing can be shocking anymore. The gender people are just going to do they're going to hold on. They're going to defy every UK Supreme Court ruling. They're going to defy every US Supreme Court ruling. They're going to defy the US administrative executive orders. They're just going to do everything they can do to hold on for as long as they can. That's just what's going to happen. And I understand why it seems baffling, but if you've been in this for 11 years, like I have, none of it is actually baffling. Like, this is, this is what they do.
Like, it just makes you feel really helpless because you no longer know where to turn, like what authority could help change things. But also, the last thing I wanted to mention, it was literally today I found out about the story that happened actually in California about the Ukrainian family who have lived in the US for, I think, over 10 years or something close to that. They have recently lost custody of their teenage daughter because they refused to kind of
Affirm. They refuse to affirm.
Yeah, no, I'm really I'm not sure how to phrase it, to affirm her transitioning. And it's the article about it is in my pinned post, so if you want to check it out, please do, and give a follow to this amazing mom who is, I've spoken to her today. She's fighting really fiercely for her daughter, and it's really, yeah, it broke my heart today when I read this article. And if you have any ideas of for who they could be introduced to, on how we could help them, please drop me a DM and I'll put you in contact.
Yeah, it's an awful case. Thank you.
It
Okay.
is. And I just want to tell you that.
Yes, jump in, Elspeth. Yes.
The case has come to the attention of a lot of the lawyers who are gender critical, and that Wolf is going to put out on its, we have a network that we're developing of women, of lawyers who are feminist, gender critical. And we're going to send out a notice on Monday to them to see if anybody can get involved.
Well, we'll probably end up having a space on that at some point. So I want to thank everybody who's been on our panel this evening or this afternoon, depending on where you are. Elspeth Cypher, Kara Dansky, Glenna Goldis, Mariah Burton Nelson. I want to thank you all for being with us. And a reminder to our audience that the Supreme Court will hear oral arguments in Little versus Hecox and West Virginia versus B.P.J. next Tuesday, January 13th. So please join us again on X when we're going to reconvene this team of experts for a post-mortem on the arguments and talk about what was said. That will be taking place on Monday, January 19th at 7 p.m. Eastern, 4 p.m. Pacific. So again, the Supreme Court cases, Tuesday, January 13th, that's next Tuesday. And then the week later, Monday, January 19th, we're going to have an X space to talk about it all. So thank you all for listening. I'm Lisa Simione for Diag, Democrats for an Informed Approach to Gender. Good evening.